In this session, I don't wish to make a very long welcome speech. Um, However, I need to introduce, say a few words about Dr. Manoj Kumar. My acquaintance with Dr. Manoj Kumar started somewhere in 2014 because of Professor Menon. And I believe that he was so fortunate enough to have traveled with Professor Menon from the late 80s when he joined the National Law School, Bangalore, when Professor Menon was a director there. And his acquaintance did not stop after completing the course, and it continued. I can remember one incident which shows the close acquaintance that they had together. Is in 2018, we had a program organized in Cochin. It was an arbitration program, and Professor Menon was organizing the event, and we did not have all the faculties who had agreed to join the event did not actually turn up. And immediately, Professor Menon called up Dr. Manoj Kumar, requesting him to be here in Cochin on the next day. And I believe that without asking any question, he was there on the next day, and he was in our midst, taking the whole day session and continuing on the next day also. And only thereafter that he returned. So he was very fortunate enough to have had the acquaintance for a long time, and I believe that he had the opportunity to understand his vision in much more better manner than any one of us. And it is therefore that I thought that once we start this program, where it is the project Complete Lawyer, where we are trying to develop develop a program based on the speeches and teachings of Professor Menon. I believed that Dr. Manoj Kumar would be the best person to start the lecture series, and hopefully many more alumni of National Law School may join. So I therefore formally welcome Dr. Manoj Kumar to this session, and I would also welcome the mentors of this project, Mr. Amit Varghese, Chief Manager Law, and Mr. Rajesh Kumar, Assistant Manager Law, NABARD, who are the mentors of this particular project, and Mr. Sandeep C, who is the convener of Project Complete Lawyer, and Mr. Safi Mohan. Welcome you, sir, to this program. And Miss Anupam Aisha, who is comparing, who is a student of Law College, Calicut. Welcome you all, my dear friends, participants of Complete Lawyer Project, to this event. And I now leave you to hear Dr. Manoj Kumar. Thank you.
Thank you so much, sir. Now we are moving on to the session of the evening. I'm delighted to invite respected Dr. Manoj Kumar, founder and managing partner of Hanurabi and Solaman Partners, Delhi, conferred the prestigious Mahatma Gandhi Solaman at the House of Lords, London. Dr. Kumar is now a top-tier name in construction law, conflict management, ADR and mediation, energy, environmental, natural resources, infra and real estate, corporate M&A, and space policy and regulation. Dr. Manoj Kumar is acknowledged for his outstanding leadership, strategy, and ability to find alternate solutions to the most critical and complex challenges across geographies. In addition to driving Hammurabi and Solaman Partners ranked among the top 15 Indian law firms by Asian Legal Business, Dr. Kumar also doubles up as President of the Indian Strategy Group, Vice President of the Society of Indian Law Firms, Vice Chairperson of the Inter-Pacific Bar Association Energy and Natural Resources Committee, Vice President of the Society of Construction Law UK India, visiting fellow with the Asia's top-ranking think tank Observer Research Foundation and chairman of Lexo, a top-tier law tech group. Today, in this evening, Dr. Kumar is here to talk to us on the topic Skills Needed for a Practice-Ready Lawyer. It is my privilege to invite Dr. Manoj Kumar to take over the mic. Please welcome, sir.
Thank you so much, Anupam. That was quite elaborate, more than elaborate. And also, thank you, Johnson Gomez, for your kind words. And of course, remembering, how our paths crossed way back in 2014. And of course, Professor Menon was an institution, as we all know. We were fortunate to have lived during his times. The 2018 incident that you were referring to was also very uniquely handled by him. I received a call around 4:35 in the evening, where Professor Menon was there on the other line calling himself. And what he told me was something that caught my attention, that Manoj, I've been trying to reach you for the past few weeks. Possibly you have not seen my email. I said, no, sir, it doesn't happen that way. I mean, I see you have missed it, possibly wrong email ID or something. Tell me, what is it? No, I was expecting you to be in Cochin today, and thought I'll check up personally. Are you reaching today or tomorrow? And that's how we started discussing that there was something already going on, and it was day 2 the next day, and then there was a day 3 the next day. But such was the man, even in the most uh, compelling circumstances, where he knows that he could have just given me an instruction. And 25 years into the profession, I dare say I would say no to him. And I could have anytime moved heaven and earth and freed myself to be here. But he was the man. I mean, he was so kind. He made it so comfortable, probably making it and the holding some wrong email ID as the culprit, and for a miscommunication, and allowing that softness and ease to handle. Uh, and of course, it doesn't make a difference as his protege and student in what way his instructions come. So I'm glad that it did happen, and that was the last interaction I had before he left us the following year. So it's good memories, and thank you for reminding me for the good memories. Coming to the topic, of course, skills needed for a practice-ready lawyer. Um, Now, I believe most of our colleagues on the screen are young lawyers who have just passed out or very young, early into the profession. Uh, you guys are very fortunate that you people are very fortunate that there's somebody like Sandeep, Professor Gomez, and many others who are taking the initiative and bringing what it takes to become a complete lawyer to your doorstep, especially in this virtual environment where it has become even easier to reach each other. Otherwise, setting up a classroom, etc. Now, that takes me back to my days at law school, um, how we were evolving. The 5-year program that had been um, completely conceptualized and rolled out by Professor Menon's initiative in those days was also designed essentially to create, if I can say so, practice ready lawyers, or complete lawyers from the way the bar needed, the kind of lawyers the clients needed, the in-house needed, the kind of quality of lawyering that was required in the courts. And therefore, to fill in a lot of gaps that in those days were perceived by Professor Menon, the curriculum, the entire structure of studies, the 60 projects that we did in the 5-year program, the compulsory clinical side of and the education, which was a new thing in those days, the internships, which we used to call placements in those days, the compulsory placements. So there were a lot of elements that were being thought about as to what all does it take to make a lawyer a complete lawyer, um, or a practice ready lawyer. And therefore we were kind of experimented with. And I dare say that it was a learning process. For we were, of course, starting to experience all the curriculums that were designed for us, but for the faculty and for the outside world who was likely to test us whether we were practice ready or not. uh, there were a lot of things which happened along the way. In fact, during the 5 years itself, we saw changes in the curriculum. Um, we used to go on internships or placements, as they're called now, to corporates and law firms. And we were suddenly exposed to documents which were never dealt with or taught in the law schools, things like balance sheets and financial instruments and financial documents. And somewhere down the line, we came back and we had a discussion with the faculty, with Professor Manan particularly, that today, in those days, in the 90s, when the liberalization had set in, a lawyer will be incomplete if he's not able to handle and understand financial data and financial documents. Even if somebody has to go into disputes and litigations, the nature of work that will emanate is going to be having a lot of interface with financial documentation. So while we were in the middle of our 5-year program, we saw this new paper being introduced as Law and Financial Management as an elective paper. So those of us who wanted, we could take the paper as an elective paper in our 4th and 5th years. And short point being that this whole process of being a complete lawyer is going to be a process which is going to be ongoing for the rest of your life. Even folks like myself, Mr. Gomez, and a few others who spent decades into the profession, for us to remain complete and practice ready, we need to reboot our knowledge. We need to reboot uh, our contextual understanding of the rapid changes taking place around us in the kind of work that we're doing. So, for you young folks uh, who have just who are at the cusp of your career, you're trying to enter the profession, uh, I would request you to step back and analyze what is practice ready. And only once you have understood what are the skills which are necessary for practice ready, then you go about sharpening your skills over the next few weeks and months under the complete lawyer program. I've tried to break the discussion down into 3 portions. First segment, of course, to discuss the stakeholders. What do you perceive as who are the stakeholders who you have to deal with and manage for the rest of your career, and God willing, the next 100 years as a lawyer? And then, of course, what are you expected as a lawyer to perform? What is expected out of you uh, as a lawyer by the different stakeholders who are all around you? And then, of course, when you understand the stakeholders, you understand what are the expectations from you, these skills kind of throw themselves up. They start staring at you in your face that to do this, you need this skill, to do this, you need this skill. So that's the way I've tried to analyze it. Let's spend a few minutes as we go along. And my way of discussion is slightly different. I respect the format that has been set out here. But anybody having a query in the middle of the discussion, just throw up your hand and go ahead. You don't need to wait for the last 15 minutes, at least in my session. What happens is by the time you wait for the last 15 minutes, you might just forget the query or forget the context. So it is best dealt with while you are listening to a certain topic or an aspect, and ask the question now itself, or you can choose to keep your questions for the end. I leave it to you entirely, to your judgment. Now, who could be the possible stakeholders in your career? Can I have a Q&A? Can some of you answer? Identify some stakeholders. I think let's make it interactive. Anybody would want to identify 1, 2, 3, 4 stakeholders in the practice of law, or when you start practicing law? It would be as elementary as a judge, but please go ahead. Identify more. Anyone? I can see a lot of names. I can call out Asina, Meenu, Johan, Safila. I can see only some names. There are some which are hidden. 13 of them are hidden. Anantu, Aravind. Come on, take a shot. Who are the stakeholders? Anyone? Yes, I think somebody is unmuted.
Candidates, please come forward. Even if you make a mistake, that is all right.
Yeah.
Okay.
Come on.
Yeah, please, everyone. Yes, anyone? Anandu. Unfortunately, I think we have to call one by one. Anandu, yeah. Anandu.
Yes, sir. Good
I've
evening,
got
sir.
10 names on the screen. I can
Yeah.
take those 10 names definitely. Yeah, Anandu, please go ahead. Yeah.
Good evening, sir. My name is Anantu. So I think so you want the one of the name for a stakeholder?
Yeah, I need who are the stakeholders? When I say stakeholders, I mean who are the people with whom you will be working when you start working as a lawyer.
Okay.
If you go to the court, the judge, he's one set of, so judges are one class of people, right? That's one class of stakeholders. Who are the others?
I think criminal practicing lawyers is a type of stakeholders. And
Okay.
also civil practice side is also a type of stakeholders.
Stakeholder. Okay. Shafila, you want to take a crack at it, please? I'll come to you, Arvind, after that.
So, yeah, advocate as well. Then there will be criminal lawyers, practitioners, and all. That's it.
Okay. Arvind, you want to add to it?
Sir, good evening. Maybe big corporate houses.
Okay. So clients, you mean?
Yeah.
Identify them as a class. Yeah. So clients. So courts and clients. And what else? Who else? Next, Arun, you want to take
I think bars, like communities, parties.
Okay. Bars as in bars where you get alcohol, or you're talking about
No, sir. Barrister Association.
bar associations. Okay. No, you said bars and parties, so I got confused. Okay.
No. And legislatures.
Okay. Okay. Anisa, you'll be the last one. I'll move on after that.
So tribunals, co-counsels, then respondents of the case, victims.
Yeah. Okay. So let me summarize and move on. The stakeholders that I perceive, and you can try and imagine this by yourself as well. Clients are one of the most important. Clients is one of the most important stakeholder in your law practice, and you get all kinds of varieties of clients. Clients who are very focused, who are very educated, to clients who are not totally exposed to the problem. Some may be able to comprehend well, some may not be able to comprehend well. So clients of all shades, essentially. Clients having a criminal law problem, clients having a civil law problem, a big corporate house having a corporate law issue they want you to fix. Courts and regulators. Of course, you have courts, and you also have, as much as the civil court or a high court, you also have a RERA. You have so many other multiple sectoral regulators. That's the other class of stakeholders where you need to interact with them to be able to get relief for your clients. So far we have two, right? Clients who need your help, and of course the courts and regulators where you have to go and get help for your clients. The third class of stakeholders which you'll need to deal with in your law practice is, and it'll be good if people keep the cameras on. Otherwise, it looks like you're talking to a wall. So it's always just like a classroom setting. It's good to keep yourself exposed. The other class of stakeholders is administrators and government departments, because the relief for a client may actually lie not necessarily every time in a court, but may actually lie in places where you need to interact with different government bodies or departments or government officers. The fourth class of stakeholders are the stakeholders who are partners in your day-to-day working. Your employees, your suppliers, your
Dr. Manoj, hello? I think there is an internet problem, connection problem over there. Everyone, I humbly request all of you to switch on your camera, especially the students of Project Complete Lawyer. Kindly switch on your camera.
Okay, so till my computer
Yes,
till my
yes,
computer comes back, yeah,
yes, sir.
yeah. I think
Between you were interrupted, yes.
there's some technical snag here, but till it comes back, I think we'll manage on this.
Sure.
So the next class of stakeholders is talking about are your partners in your growth, in your day-to-day working. These class of people include employees, suppliers of goods and services, your technology supplier, your ERP handler, somebody who takes care of your entire back office, your HR team. And the last class of stakeholders, which is very, very crucial, which some of you mentioned about criminal lawyers and others, is your colleagues and associates, your legal colleagues, your associates within the office. And all these stakeholders together are going to ensure how well you succeed in your law practice. And therefore, with these stakeholders, you need to work and you need to plan now. How do you need to devote the rest of your professional life? And the best calibration that you can have with these stakeholders, that will define how well you succeed in your career. Now, as a lawyer, from all these stakeholders, what is expected out of you? What are you getting ready for when we talk about complete lawyering or a practice-ready lawyer? What are you getting ready for? Most important stakeholder for you is your client, and then all other stakeholders come after that in that succession as the opportunity moves. So from the client perspective, the client looks at you as a strategic advisor. Essentially, you are expected to solve every problem a client has. And the variety of problems differ from A client to B client to C client, depending on the background, the nature of business, and the nature of activity, and everything that goes around the background of the client. But one thing is common across the string of clientele in today's lawyering compared to what it was 15 years, 20 years ago, when clients would walk up to a lawyer only when there is a pre-existing problem. Now, the lawyers are looked as partners, and therefore, any good or major initiative, you're looked upon as a strategic advisor to give solutions, to give advice, which are not necessarily very legal, as just reading out the sections of the Bayer Act, but being able to comprehend the implications of law and guiding the client how to progress, how to take the next step. The other aspect you are expected to deliver to a client is that you should be able to prevent their problems, not solve them when the problem comes. So therefore, when you are articulating a response for a client, when you're guiding and handholding a client, the expectation is that you don't just solve the problem today, but you also move beyond this and please tell us how to avoid similar issues in future. And even if the client is getting into a new area or new work, or getting into a new transaction, whether it's a small real estate transaction or a new business, then how to avoid or prevent breaches or difficulties, legal difficulties going forward. The third role expected from you is that you don't just deliver what you are good at, but you help the client achieve the transaction from end to end. So there were days when clients would talk to a lawyer, and the lawyer would say that I'll appear in your case. Um, I'll prepare this draft for you. But everything else around this, you have to take care. So you come, get your person, get sets made, filing, etc., etc. If it's a transaction outside the court, which had a documentation leg, the lawyer would just approve the draft and leave it to the client to take care of everything end to end outside. And there would be, of course, other service providers to bridge those or fill in those gaps. But now the expectation from every lawyer is that you should give a complete end-to-end solution. If you don't, then the client would invariably compare you with another lawyer and probably take the work there, and you be at a losing end. Therefore, it's important to face the reality and train yourself to start thinking as a complete transactional lawyer. Even on the dispute side, it's a dispute transaction now. It's not a dispute or a matter. The client looks at end-to-end support right till getting the final result in terms of the commercial result from a dispute. In providing all these expectations from a client, the other aspect that becomes very important is how well are you able to handle your clients and your peers. So soft handling, I'll come to that when I come to the skill, but you are expected to handle your peers and your clients in a very unique way, which ultimately helps or enables the achievement of the business goals or the achievement of whatever is the goal of the dispute or a transaction that is going on. As I mentioned, you should be a solution finder. Even if you don't know all the answers, you should be able to get the answers and solve the problem of the client. And last, expectation from a lawyer of today is that you have to be a thought leader. You should be able to talk beyond and ahead of your time. You should be able to visualize and see the trends, the changes. The clients would not want to be dependent on a legal magazine or some kind of an online portal who get articles together to tell the client, because every client, whether individual or corporate or a business client, is obviously planning 10 years, 15 years ahead. The way you are planning your career for the next 25 years, every person who is likely to pay you money for helping them to handle their legal challenges is also planning the next 25 years. So put yourself in their shoes, and then you need to become a thought leader. You need to know much more law than what an average lawyer is expected to know. So never accept a mediocrity. You need to move ahead of your time and do research, keep researching, keep sharing the research papers, keep sharing the outputs with your clients. Having discussed the stakeholders and the roles expected from you, let's now move on to what skills are required for a practice-ready lawyer. And I hope you're able to connect some of these dots, how these skills are going to help you bridge between the expectation from you and your best handling of the stakeholders we discussed above. First and most important skill of a practice-ready lawyer is to have a very out-of-the-box thinking approach or ability. Your analytical ability is the key to how you are able to think through a problem. It reminds me of a small story of an elephant in a dark room, where 5 people were left in a dark room without a light and an elephant in the middle of the room. and they were asked to find out what animal is it in the room. So someone who caught the tail thought it was a snake. Somebody who caught one of the legs thought it was a pillar, and so on and so forth. Now, different lawyers can visualize the same set of facts and the same problem very differently. But the best lawyer is the person who does not think on predictable lines, who does not get limited by the letters of the law, who does not get limited by what happened in a similar case in the past, who is always ready to think out of the box and always think in today's context and try and find a solution in today's context. So developing a good analytical ability is a very important skill. And that's something which you can develop by being conscious about your approach of thinking and always testing how others would have approached the same problem. The other one or two important skills, which are, I'm sure many would have told you, is very good research skills. Now, research skills are as any other skill, it has a lot of shades from white to black, all the grays in between. Some people prefer to manage with even doing a legal research on Google. And there are others who want to go to the last mile and check exactly what is the position on a question of law today. Reminds me of our days when we did not have computers and the SEC onlines and Manupatras of the world. We used to do completely manual research, and we used to pull it off at least to the last 15 days. Because every 15 days, the journals would come, which would get compiled into a monthly this thing, and that would get compiled into a yearly. At worst, we would be outdated by 30 days. And this I'm talking about days when there were no computers and no online data banks. So our way of research was actually quite structured. We would start with the textbooks for the conceptual part to not lose out on any essential concepts, but then quickly move on to the moment we move on to the judgments and court positions and the latest position on that question of law. AIR manuals, annual volumes, year on year, we would check for that section till we reach the last year. For earlier years, it would be a 10-year volume. For the last 10 years, 1 year volume. It used to be hard and tough, but it really helped develop the analytical skill and how to help go to exactly the root of the problem, the last mile. That is something which has started going amiss or missing out in the young lawyers who are coming out now. You should not fall for it. Always do your research very deep and very sound. Next, of course, is drafting. Well, from the point of using a template, somebody else would have done it in the past. Take that and use it. That's the easy way that can save time. Start with that, no problem. There's always some place to begin. There's no point dictating a 140-page petition every time you need to draft it. Maybe about 100 pages out of that are standard paragraphs. But whenever you're using a template, ensure that you adopt it properly. That is one. So your factual incorporations are a key. We have had situations where High Court judges have flagged to the lawyer that, look at this, your brief says something else, your annexures say something else. So by mistake, the juniors or the lawyers of that office forgot to even change the dates of the corresponding letters, which was the dates of some old petition, which would have got disposed of, went in here. So don't make those kind of mistakes. And the other very important part, in addition to just the factual aspect, when it comes to grounds and your prayers, applying the facts to the law, applying the law to the facts, whichever way you want to look at it, and identifying the applicable grounds for yourself, and how lucidly you are able to do it. It's like you're talking to somebody. If you complicate it too much by using too many Latin words, or trying to draft as if you're writing an answer sheet and you'll get the numbers based on the weight of your petition, you may not really get the results because the judge may not have the time. to either open the dictionary and find out the meaning of all the Latin words, or have the time to read up your 500-page brief. So how easily and how simply you are able to communicate. Simplicity, simple English is a very critical part. And based on that, whether your prayers, you may want the world in your prayers. Your client may tell you, okay, put these 5 prayers, this is what I want. But unless you are able to connect your prayers backwards to your grounds and uh, facts and your analysis, it doesn't come, it won't come. So it's like a living organizer, living being. Every petition is a living being. It breathes in itself. It depends how well it will succeed. It depends on the quality of life that you are able to put into the brief each time. And you have to do it every time. That's called excelling. And that's what great lawyers are made of. And we have had inspirations in our days. I'm sure you would have yours. Of course, the other important skill is advocacy. Uh, just the way you are able to write lucidly, you need to be able to talk lucidly, talk the right thing at the right place at the right time, with the right punctuations, with the right cross references, to get what you want from a court, a regulator, a government servant, a government department. Just think, anywhere you go for a relief to get a solution for your client, advocacy is one common thread. Therefore, work on advocacy, develop your advocacy skills. Try and one of the very important abilities of advocacy I keep talking about is to be a good listener. If you're not a good listener, you'll not be able to do justice to advocacy, because there's one thing about what you know, but there's another thing what the other person knows, and how to bridge and find a way in between for your client. So to know what the other person knows, to know what the court knows or what the court's understanding is, to know what regulators or a government department's understanding is, you need to be a good listener to be able to give you time to articulate, to calibrate, and to finally get your client what they want. So, and of course, sharpen your advocacy skills and undertake some clinical programs, um, unless you have done them already. If you still feel the need, do a lot of uh, training with good advocates who are known for their court craft and crafty advocacy skills, and develop it. It will go a very long way for your whole life. The other important aspect is your adaptability to technology and tools. We have been in a generation where we passed out, we didn't have computers. But the moment we got into the profession, we were exposed to a WordStar computer, which we didn't operate. There used to be a computer room and some 5 operators who take dictation from us and type and bring. And from then till now, where we're doing everything ourselves. I honestly don't need technical help, and I'm sure none of my colleagues needs, and so would you also not need. But somewhere in between this familiarity of MS Word and Excel and computer and phone lies the solutions, the technological solutions to make your practice more efficient. They could be good data banks, legal data banks. They could be technologies which can expedite templatization, which can help you bring your drafting to a certain scale and quality at 1/10th the time. So it unlocks your time for doing other things. So technology, the e-bots are now a reality where your clients are already using e-bots. So every time you give a legal advice to a client, 2 things happen. One is the client's problem is solved. The other is your solution goes into the e-bot system of the client, and across the offices, when the next time somebody has the same query, the query doesn't come to you because you will charge again. The e-bot answers that query because your opinion is already on the brief of the client. So that's the scale at which the client is moving. So therefore, you need to move much faster, evolve yourself, to differentiate yourself, to keep your space, that your e-bots cannot solve all your problems. I need to work with you and the technology to be able to help the client, as in yourself as a lawyer. So you need to adopt technology much beyond and much deeper And then what you may have thought that you already know good use of computers, Google, all the basic technologies, but now start focusing on the legal tech part of technology. Peer handling, as I mentioned, it's very important. If you are able to have 10 happy faces, happy minds as a part of your team, you grow 100 times faster than compared to having 5 happy minds and 5 unconvinced minds in your team. Your growth is defined now by your peers' uh, quotient or contribution or loyalty or commitment or oneness to your cause. And when I say colleagues, mind you, it's not just lawyers. Your accountant matters, your admin person matters, your filing boy matters the most. Your filing boy internally in the office matters the most. If he makes a mess of your papers, God help you if something goes wrong there. So every part of that machine, which is all the human elements of your practice, peer handling, I think, and to start with, I think start with patience and compassion. These are the two street skills I'll throw at you. Uh, because the more stress you get under, you start throwing these two things out of the window. When something becomes very urgent or your client has put you under a lot of stress, when it comes to human handling, the first two things that you throw away, one is compassion for your colleagues because you start being loud and you think that they will understand your pressure. No, they're different people. They're working under their own pressure. Your client, you are exposed to the client, not them. So you need to be able to buffer between the two. So keep your compassion quotient intact. And the other aspect is patience. You start throwing your own patience away. You start taking the pressure. And that's when it starts becoming difficulty in PR, in peer handling. As I mentioned, financial data handling, again, unless you are already exposed to, no matter what area of practice you are, disputes, arbitration, corporate, labor, anywhere, tax, I think your ability to not look at financial data and financial documents as something alien is going to be very, very crucial. So start, working on that aspect unless you already have done these. The last two things that I want to mention here before I close the discussion. One is that you need to be a learner all your life. So once you complete this program and you are honored with some kind of a certification that you are a complete lawyer, don't take it too seriously. It's every 6 months you need to prove yourself that yes, I'm complete. That's a lifelong process, as I mentioned earlier on as well. So it's a good starting point. It's a good confidence building measure, and it'll definitely change your outlook. But always keep it in mind that you have to be a continuous learner because the environment around you, the law around you, the entire working system around you is changing far more rapidly than what you think of. And the last skill that I want to leave you with as an input is not very common to come from most lawyers is memory skills. We always have some people in our circle who remember citations like this on top of their fingers, who remember everything like page, para. Now, these are skills, and maybe some are born with it, but these are skills you can acquire. There are scientific tools and methods and clinical courses, very short ones, which help you build up your skills to remember a set of 1,000 facts completely unrelated, but how to organize them in your mind. And once you apply that method to, for example, an arbitration act, the day you decide that all the sections from one to end, I will memorize, it's achievable and doable. So whatever your area of specialization is, if you have an opportunity and if you have time, find out what these memory skills are. Uh, Join some of these programs, try and sharpen your skills. Get to 30%, 40%, 50% level, to whatever level you can come to. Anything starting from zero being where you are, not that you don't have any memory, but zero being where you are, anything increasing from there is going to have an incremental effect on your ability to deliver better than other lawyers, or to be a better complete lawyer than other complete lawyers. So these were some of my inputs, and hopefully it has made some practical sense. That was the effort, because of which I did start with a interactive question and answer session. And over from me, Sandeep, and I'm okay to answer any queries or clarifications that anybody may have.
Thank you so much, sir. Thank you. Okay, now will start the Q&A session. Candidates can either unmute yourself and ask a question, or you can just type down your question in the chat box.
Good evening, sir. I have a
Good
question.
evening. Yes.
So what about the code craft? How much it is needed for a complete lawyer? And also I heard that while you are pitching a case in front of judge, that is also different. That means that different vary from judges, right? So how that will affect our present case or something like that? So that means that attire and code craft and that those all things, how it affects us.
No, sure. So, the term advocacy, which I used as one of the skills which is very important to acquire, advocacy is essentially your ability to talk to somebody and get the result that your client needs. Now, whether talking to a judge in a courtroom, or talking to a regulator in RERA, or talking to a government servant, some IAS fellow somewhere who has to give some permission, environmental clearance, these are all advocacy skills. And how best you are able to articulate, depending on the person in front of you, the nature of the relief that you're looking, how best you're able to articulate your presentation so that you get the result that you need, is the code craft that you are referring to. It is very, very important and very integral. And therefore, I suggested that if possible, try and sharpen the skill by undertaking some clinical programs on advocacy, and spend some time, as I suggested, in courtrooms or other places where people who are perceived as being, who have excelled in advocacy, who have excelled in court craft, you are able to imbibe. From personal experience, what I can tell you is most of my learning has been passive learning during my internships and placements in those days. So if the more time you spend with the best people while they're doing their best quality of work, chances are you'll develop, you'll probably pick up some of those skills, which then you can sharpen as you move ahead.
Thank you so much.
Sir, am I audible?
Yes, of course, Revati, you are audible. Please go ahead.
Yes, as you mentioned about e-boards, will e-boards replace lawyers and advocates, on what extent or what probability it will happen, or as an advocate or lawyer, what we can do to limit it?
Yeah. So that calls for a very long discussion, Revati. We can have a long chat on that, but I'll try and keep it short and answer. So what is happening is law practice, advocacy, the way it is defined in the Advocates Act, that is an area which is protected for you, and no machine can take over that area. And we are also using those provisions to limit chartered accountants and cost accountants and company secretaries from crossing over to law practice, because that's an area the law protects for us. Having said that, there's a lot of gray area in actual day-to-day requirements. Things like templates, a letter, a will, an application to RERA for something, Some of them the law has already provided, some of them can be templatized by us. Similarly, some queries, answers to some basic questions. The FAQs you are aware of. In print versions, we see these FAQs, frequently asked questions. Now, FAQs in a more modern context, in technological context, are being put into e-bots. Now, only difference is that more and more of our answers, which are legal answers, are also finding their way into the e-bots. For internal working, I don't think it's something that is capable of being stopped. And we should be ready to face the challenge rather than trying to stop people. Replacing us as lawyers, technology is definitely here to take over. Artificial intelligence is moving at a much faster rate than I and you can imagine. And there are already technologies available where a client can develop almost 98, 97% accurate document on the pleading side as well as a transaction document side. So with that kind of accuracy, the problem where that falters is the machine or the artificial intelligence cannot certify or give a closing opinion or give a view, which is something important for a board to close the transaction. The board still needs a closing opinion. The board still needs a compliance report. The Companies Act still needs manually a compliance report to be adopted by the board. And if there is a glitch, the board of directors will go to jail. So people are still not easily, accepting the AI. So space for lawyers is there. But if I was you at this stage of your career, beginning your career in 2021, not in 1995 when I began, I would want to develop my skills in areas where the machines cannot. So I would want to deliver to my client value. When a client comes to me, if I have to pitch before that client, what all I can do for you, I would rather start saying that, small things like wills and basic queries, anyway, you take it from Google or you may get it from somewhere. But those anyways, if you want, I can give you. But what more I can give you is 1, 2, 3, 4. And identify those areas which machines cannot offer. Some of them I mentioned here, thought leadership being very important. The traditional perception of a lawyer is a lawyer who fights cases in the court. Today, the perception of the lawyer is a lawyer who can sit, have a coffee table discussion with my team and tell my team, who are all non-lawyers, how to do their business so that they don't breach the law. So it's a different thing altogether, being preventive, being articulative, being able to look at the future way beyond what the existing laws is, being able to predict and perceive the changes which will come in the legal environment in any given sector or any given area. No, work on areas, think through what machines cannot do and skill yourself in those areas. I think there it's a protected land and it will remain protected.
Thank you.
So, can you throw some light on inculcating good negotiation skills which is required for a lawyer?
No, so negotiation skills, how to acquire them, I think is a separate clinical program of its own. But yeah, when we talked about how best to handle your stakeholders and your clients and your transactions, I think being a good negotiator is very, very important. The way I approach negotiation skills and mediation or similar skills is that these are not skills which are only relevant when you're pitched against the other side in a given matter. Because your skills, these are interpersonal skills. These are skills of how best you can understand people around you. It could be a colleague, it could be a judge, it could be a court clerk, it could be a lawyer on the other side, it could be a client's respondent in a negotiation meeting where you're sitting face to face. It could be any person. So these are skills which are integral to your peer handling and human handling skills. And you should sharpen these skills. And if you just take it away from this old perception that negotiation skills are only used when negotiations happen, you'll be surprised that they help you in every walk of your life, every walk of your professional life. So definitely it's an area, and you should strengthen negotiation skills. And the answer to these will lie in human handling. Just focus on that and you will see how much of your negotiating ability is getting unlocked. You know, the most difficult people around you, if you can get your work done very easily, you're an excellent negotiator. The day you are placed before a lawyer across you, you will see how easily you manage. So today itself, just start handling the most difficult people and how best you can handle them. That's your starting point of acquiring negotiation skills. Yeah.
Sure, sir. Thanks.
Sir, am I audible?
Yes, of course.
So how should we enhance the analytic ability of problem-solving skills?
So there are different methods of doing it. One simple method, which could be a good starting point, and then you can do some advanced reading on analytical skills. One simple way is to always discuss any problem in multiple probabilities. So whenever you have a problem before you, the usual human instinct is to talk about two probabilities, either A or B. That's what the normal mind says, that what could happen. This is a problem, what should be the right way? So you look at two options. Start thinking where the other person would stop thinking. That is your first approach. Just try and inculcate this in your thinking process and in your mind. And every time when you have a problem, ask yourself, have I explored all the probabilities? Could there be more probabilities? Are there other possibilities that could happen? Simple answers to simple questions give only simple results. Different solutions or different ways of thinking, for somebody who may not conceive, to whom a certain possibility may not come to the mind, will never be able to work on that possibility. So as a starting point, simply said, start with an approach that you'll work on any problem with at least, for example, 4 to 5 probabilities to start with. Even if it's not coming, think. Just like chess, go 2 steps back, 2 steps forward, do some permutation combination. You'll be surprised how solutions throw themselves up. This is not the right forum to discuss specific cases because some of them may be sensitive, but there have been cases where we have found solutions in completely, so at a very indicative level. So national highways, for example, so it's all works under a concession agreement which was prepared by the Planning Commission in some days, and there was some difficulty there, and that difficulty was brought to us as lawyers by 2-3 top of the line construction companies and their federation. And the simplest answer was to go and get a stay from the court. But the stay we got, the stay does not, give progress to the business, because of 5 years of stay on road construction means the country going back by 5 years of road construction, and also your client going back, your client also losing revenues. So then that's not the solution. That means getting the stay was not the end solution. Your end solution is something else, for which when you start thinking afresh, you start thinking out of the box, what comes out is that you need to bridge between the Planning Commission, Ministry of Highways, NHAI, find a common ground and get this clause changed, which is a completely legal exercise. So I'm just giving a hypothetical example. I won't get into specifics on this, but only when you start looking at multiple probabilities and not get limited by how a normal person would limit, and to test it, just have a conversation with 3 of your colleagues separately. Same problem. They go, what people say? Chances are that all 3 will talk about 2 probabilities each. And the third one may say one more third probability. But you can also do the same thing and just be that average person. But high achievers, always have a different track of thinking. So that's how that fast track route comes. It's all interconnected. Does that help?
I believe Alexi is the one who asked the question, and she might be having some technical issue.
No issue.
Yes, sir. Thank you, sir.
I believe we can have more questions. Any 4 more questions from the participants? Any more?
That's good.
Kavita, I believe. Kavita, you have a question to ask? Kavita has gone offline. Yes. Anyone? Anyone other than the participants can also ask questions.
Hello, sir. Audible or no?
Yes, Kavita, you are audible. Yes. Kavita, you are audible now. I think Kavita has a question, but she is having connection problem. Sir, meanwhile, let me ask you some obvious question, and I believe the students may also be having that question in mind, and they might not be asking the same. It is a very obvious one. The question is, you see, what is your opinion in your point of view? How can a young lawyer, fix the fee, and how he can claim it from the client? That particular question I was expecting the students to ask. It is something that is very challenging. It's very mundane, but it's nevertheless maybe challenging for the students. Can you put some lights on it?
That's not an easy one, but
yes.
Some wise person at some point told me that what you deserve as a professional is not what you think what you deserve, but is actually the budget the client has for you. So it's very difficult to put a figure to yourself. It's very important to understand, what does the client think about you. So again, it goes back to some of the skills that we talked about, handling your client. If you have your right way of dealing with your client, you will possibly know how much money is put in that wallet separately for you, and that should become your fee. If that helps answer your question.
Yes, sir. Yes. I understand.
Sir, may
yeah, sure, please.
Sir, the technological advancement also negatively impacts or reduce the chance of advocates in the particular matter. So, how can the improvement or how can the advocates recover the particular things?
Can you give an example, Renju? It will help me understand.
Sure. So nowadays the clients gets each and every details of legal things from the internet, Google, like that. So this will negatively impacts the role of advocates in the particular matter also. Yeah. So how can the advocates do better, or how can recover the particular thing?
This is just about infringement. So a client who is relying on Google to solve a legal query, he is possibly going to the neighborhood quack who is not licensed to practice medicine. Okay, so you can't do anything about such people. You can just tell them that you are fools. You're taking big risks in life unless you are ready to take the risks. As I mentioned a little while ago, the technology by itself is going to grow. And, of course, we're talking about e-bots is one. Even in the areas where we are working, artificial intelligence is being seen as a threat because it's possibly able to, even e-mediation is being thought about, that some machine is going to be able to conduct the entire mediation process. So are we looking at that e-lawyer also? So 3 computers, the client just goes to one computer, the other client goes to another computer, and there's a third computer, all 3 of them solve it. That would be oversimplifying things. So one part is things which are routine and in the usual course of business, we have to accept it that for consumer sake, for the sake of our clients, because they should not be made to pay 10 times the price of something which has now become cheap, which is easily available, which has become templatized. So there, no court, no government, no policy is likely to come and save us. But of course, we need to continuously work, identify areas where technology cannot have a role, where a legal mind has to be applied, a direct analysis is involved, responsibility is involved, because you take responsibility of professional responsibility when you're doing the practice of law under the Advocacy Act. Neither the machine nor Google nor the e-bot can give this kind of a professional accountability to the client. So, of course, even in our offices, I see the trend that very young lawyers, when they are given a query, they quickly Google and come back with an answer without realizing the client has already Googled before they came to us. So they're possibly telling the client the same thing which the client already knows before sending the brief to you. The client has also Googled those same search words. So, and they learn it in one or two mistakes, they learn it. So it's a challenge. Google is not going to be able to take over law practice. It's just a data bank, unverified data bank, no certification, maybe expired medication, capable of hurting people. It will show you some nice article written in 2021 on a question of law, and somebody will quickly take it, apply it in their legal opinion, send it to the client, only to realize that just last month that legal position has changed, which Google has not been able to catch up, because that journey from the court's chambers, judges' chambers to Google takes more than 35-40 days. So we need to be very articulated about this, Renju, and we need to work in areas where we can excel and, and of course, don't give the client comfort on Google. Keep telling them that Google is a quack and you might end up, hurting yourself, which we do all the time.
Manoj sir, one question.
You are so experienced yourself.
And the point is, now all of our participants are participating in a complete lawyer project, and they have, suppose they acquire all the skills that are needed. How to start the practice? What next? What immediately next after this? What is the starting point, and how shall they proceed? Can you shed some light on that?
Yes. So acquiring the skills and being able to convert that skill into business are two different things. And what we're talking about here is the first first phase of acquiring the skills, and also possibly guiding people on how to convert it into. But the actual conversion is something that has to happen later. So I'll very simply put, even I founded this firm at some point in 2001. Very simply put, for a law practice to get started and get moving, it requires stakeholders that we talked about earlier in the beginning. The stakeholders required a client and a lawyer and somebody who knows the law, at the least. And then comes the judges and everything else later. Only if you get a brief, you will go to a judge. But the first starting point is a client, a lawyer, and a lawyer who has the right skills. Now, how do you bridge these dots? So a lawyer you are, the skills you are acquiring just now. In a couple of months, I guess you would have honed all these skills to a sufficient level. Now the point is, how do you bridge to the client? What bridges can you build? How does a client know that there is a certain Arvind or Renju or Anupam or Revati who can do this for me? How do you get into that mind space? How do you get into the knowledge? There are very simple ways. One is reaching out to your client, even if it is in one client at a time, or the other is thought leadership, where you undertake initiatives by which, although you're doing a couple of things, the collateral benefit to the client and to you is that you start collaborating with different clients in different potential clients. People start knowing about you. Not everybody can do it. You cannot have 300 PILs every year to make 300 successful lawyers. So there is no single answer which lies for every one of you. Could end up filing a very unique case in the court, which could be a starting point for you. There could be somebody else who is able to discuss of a problem while others are still thinking about it, but is able to discuss with certain solutions and is able to get the people who are facing that problem on the table for discussion. In Bombay and Delhi circles, we call that phase general counsels because they are representing the client. But in different towns and different cities and different setups, the clients remain the main focus areas. So you have to be able to identify what bridges to build to connect you to a potential lawyer, and you have to continuously work towards building bridges. There's no single bridge that will open up the gate for you. Out of 100 attempts, you get a conversion of 1 or 2. That's the kind of rate when you start. And for 6-8 months, it could be 0. Patience, perseverance, a lot of things that we talked about earlier. Don't lose your patience. Don't come under pressure. Have enough liquidity in your pocket to outlive what a normal person would. So it's very unique that most clients, when they look at a fresh face or a fresh lawyer, they are compelled to wait and verify if you are able to stabilize, because their transactions are not for a couple of months or couple of years. They're looking at relationships which are permanent. So they would want to put their eggs in that basket which is stabilized, which doesn't shake too much, which is unlikely to fall and break the eggs. So you need to be patient and be able to stick around there for sufficiently long time. And to all my colleagues, I keep saying that when you get into a practice of law, never think of a plan B. Because if you think of a plan B, that plan B will sooner than later become your plan A. Because the moment you plan B means you have an alternative in mind that if I fail here, I'll do something. So we accepted failure. And law practice never honors anyone who accepts failure or who even thinks that they will fail. There's space for everyone. But to be here, the determination, all this will open up your way to build bridges to the client. Coming back to Mr. Gomez's query, it's just the thing about connecting the dots between yourself and the client. How soon you're able to do it, what methods, you can innovate methods, and what others cannot do, what others cannot think. I think building the bridges is what you focus, and be patient and just keep building bridges. Because when it starts paying up, it pays you in volumes. So don't worry about returns. Does that answer, Mr. Gomez, some of
Yes, sir. Yes, sir. I think that Deepthi has a question. No?
Yeah.
Deepthi
Yes,
has
sir.
raised. Yeah.
Yes, sir. Good evening, sir. I have a question that is somewhat related to the answer which you have now given, sir. So, mostly every lawyer, he enters the profession with a lot of expectations and excitement. And often the initial years of practice, they are a bit challenging, especially when it comes to your financial returns. The way your family and the society, they teases you saying that you're just going to the court to to say the lies and not earning anything. You're still dependent on your family members. And there is a lot of challenges a fresh lawyer faces. So, and often we see a trend where the junior lawyers, they opt for more secure jobs like bank, private sector by leaving the profession. So, what is there any tips by which a lawyer could self-motivate him during that waiting period, or how he can best make use of that waiting period? How he can equip himself during that waiting period? That is one question. And the second question is, often the junior lawyers, they have a trend of joining the immediate option that is available. They just make a very random study, a peripheral study regarding the available offices, and they opt a chamber which is either near to their residence or which has a very comfortable working time, etc. Is there any tips regarding the selection of a right chamber which would actually equip you in your long journey as a lawyer? These are my two queries, sir.
Sure. So, it's not just young lawyers who are moving to different options. At every level, it's a matter of choice. Why I'm saying so is that it's not a negative thing to decide to go in-house or to decide to go to a government job or to decide to become go to the lower judiciary as against practicing. Each of them are great in their own right. It's just a matter of priorities. And one thing, respect everybody's priorities. The moment you start grading them as A, B, C, D, one, you are demeaning the people who have gone for what you perceive as B, C, and D. Second, for yourself, you are attacking your self-confidence. So change that outlook completely. And young lawyers, don't look yourself with self-pity. Lawyers of every age group have the same challenge. You know about young lawyers because you are young. I know about this older lawyers because I am old and I'm exposed to them. So there are all kinds of pressures and pulls and pressures. Sustainability being the most important one that you are referring to, how to sustain yourself financially as well as non-financially, in terms of your confidence, in terms of your outlook, in terms of your commitment and motivation. So sustainability is a challenge at every level of lawyering, because whenever you move out of one level to the next, every time you're moving out of the comfort zone and you're trying to move to the next level with a bigger vision. Whenever you move out of the comfort zone, you face the same sustainability challenge on financial and non-financial issues. So one thing is about change of outlook. I think we should think about these things a little more positively. On how to spend time and what to do initially. As I said, once you are a qualified lawyer, the two areas that I would recommend you focus on. First area is how to keep working on building bridges to potential clients, which I ended with my response to Mr. Gomez. That's an area which should be your full-time occupation. And be innovative, be thoughtful, try and discuss, meet people. But that should be on the top of your agenda to gain insights and gain methods, and also spend your time meeting the target clients. Maybe you're not taken seriously in the initial, but then your other work will bring you into more serious focus amongst your potential clients. The other area where you can spend your time is on sharpening the skills that we developed. As I said, you will never, every time you think you are a complete lawyer, 2 months later, the profession will tell you are an incomplete lawyer. So that journey is a constant journey. So use your time wisely and try and keep your skills on the top of the pack. The other part of your question on selecting the right chamber, I think it's important to have a vision of what you want to do. The challenge with most young lawyers now is that law schools, at the time of taking admissions, and for various reasons, they're justified, they have costs to incur. I'm on a few boards here and there in some of these law universities, so I don't want to unnecessarily ridicule, but I'm saying law schools are able to sell dreams. So when you join a particular law school, you kind of assume that you are in the Ivy League. So when you come out, you'll get the blue robe treatment, and therefore there's nothing difficult for you. When that happens, when you come into the profession, there's a big difference between the two worlds. So that setback kind of derails the entire understanding of a young lawyer. The other is that because of that dream which has been sold to you, you have not created your own vision about your career. You've just got carried away by the options or abilities that the law school thinks you have and the opportunities that lie for you. So most lawyers, when they're exposed and when they have to decide what to do, where to do, who to choose, who to work under, I think a good amount of counseling, if you are already aware that you want to specialize in arbitration, for example, at a very early stage, then even if Mr. Gomez's office is 20 kilometers from your home, you should target joining him. Similarly, if you're clear that tax is your area of practice, try and find out the top 2-3 tax lawyers, and distance should not come in the way. Now, how this counseling is to be done, who does the counseling? Logically, this counseling should be a part of the passing out curriculum from a law school. If that is not happening, the rest of the people learn the hard way after losing a few years and realizing that just being close to my house did not help me emerge as a great lawyer. I need something more than this. But this counseling is a gray area, is a deficit area. And the more you can spread and at least ensure that your peers do not face the same problem, try and help them solve it. But you need to have your vision, you need to have your focus where you are heading. In case you don't have a vision, try and go to an office which is a multi-speciality, so that it can help you choose one area of practice, and then you can develop it from there. But always think where you're going. Does that answer? Anybody else?
Sir, we have exceeded the time 15 minutes, but I think there are 2 questions remaining. So I think we can send those questions to your email, and if you
do that,
you can respond, right?
Yeah, do that.
Okay. My apologies.
No, not at all.
We ran out of time. Okay, dear students. So if you have any questions, we will be sharing the email ID of Dr. Manoj Kumar sir. So he will be willing to respond to your questions. Okay. So Anupam, yeah.
Yes, sir. Yes. Thank you so much, sir.
I
would rather recommend that all the questions be compiled by one person, and any one person can mail it to me.
Sure. That will be good.
It's easier to handle. Otherwise, some mails may get lost and may get ignored.
Yes,
which
yes,
is not.
We will do one thing, and we will give the students time to send us the questions, and we will compile it and send it to you. That will be good idea. Yes. Okay. Anupam?
Thank you. Yes. Thank you so much, sir. That was a wonderful session, and thank you so much for giving us your valuable time. So now we are moving on to the end of the session. We have Mr. Sandeep Chandrasekhar, Joint Secretary, Law and Justice Research Foundation, Kerala State Chapter, as well as the convener of Project Complete Lawyer, here to give us a vote of thanks. Over to you, sir.
Thank you, Anupam. It has been a wonderful evening. It has went beyond my expectations. It's always a pleasure. It is a pleasure finally to meet Dr. Manoj Kumar sir. I have heard a lot about you from Johnson sir, and every word that Johnson sir has said is true, and you have gone beyond it, because the topic you have taken is very difficult to explain within 45 minutes or so. But with your experience and wisdom, you have done it. Narrow it within a few minutes and divide it in a systematic way, and actually encourage the students to ask questions, raise doubts within their minds, and the questions also asked by the students are also very difficult to answer, and surprisingly
excellent questions.
Yes.
Very analytical questions.
Yes, definitely. And the questions are very difficult, and even more very difficult to answer within that limited time. And but nevertheless, Dr. Manoj sir has done excellently. Thank you, sir, for your valuable time, your wisdom, and we hope to see your full support in the coming future to conclude the to conduct and conclude the project Complete Lawyer in a successful manner. Thank you, sir, for spending your time with us. I would also like to thank Johnson, sir, as a courtesy. He is with us from the very beginning with regard to Project Complete Lawyer, and this was under his leadership, along with the cooperation of Law and Justice Research Foundation. This Project Complete Lawyer has been conceived. Of course, fundamentally inspired by the writings of Dr. Menon sir. And I would also, in this occasion, would like to thank Safi sir, Assistant Professor, Government Law College, who is the founder of Law and Justice Research Foundation, who is also has been very inspirational in actualizing Project Complete Lawyer and organizing this particular event. I would also like to thank Rajesh Kumar sir, who is the assistant manager of the legal department of NABARD, who has been also instrumental in organizing the Project Complete Lawyer. I would also like to thank the student coordinator Anupam, Amina, who are the student coordinators of Project Complete Lawyer. I also like to thank other members of Cochin Institute of International Arbitration and the Law and Justice Research Foundation for organizing this event. Finally, I thank the students of Project Complete Lawyer, the candidates of Project Complete Lawyer, for participating in this event and asking those valuable and very relevant questions. Thank you all. So the event has been concluded. Thank you for your time.
Take care. God bless. All the best to all the students.
Thank you.
Thank you for having me.
Thank you, sir. Thank you.
Thank you, sir. Thank you.
Thank you so much.